more of its innate privacy. A very good afternoon to one and all. I am standing before you all to speak about the Right to Information Act 2005 has got negative impact in India in respect to the transparency and accountability. The Right to Information Act 2005 is to provide for setting out the practical regime of right to information to the citizens. Under this Act, any citizen of India may request information from a public authority which is required to reply within 30 days. The Act has been provided to promote transparency and accountability in relation to the administration. But the authorized officers, the authorities who are responsible to whom the request for information has been made are overburdened with these requests. Since the authorities are already having a lots of work and tasks to be delivered at the end, after the Act has been passed, they have been burdened with the additional work. Since India is an immensely populated nation, the population is more. There is more requests have been made to the officers. Due to the overburden, sometimes wrong information is also given to the people out there. So clearly, the Right to Information Act 2005 is creating nothing but an unnecessary chaos all over. Even though the government has appointed multiple public information officers, but this has resulted into running of citizens from one office of PIOs to another office. So clearly, this is time consuming and hectic for the people, because sometimes people have to wait for the PIOs to meet them. They also have to get the security pass to meet PIOs. So it is clearly time consuming and hectic. Further, RTI Act provides for the information on demand, as to speak, but does not sufficiently information on the matter related to food, water and other survival needs. The Act does not emphasize active intervention in the educating people about this right to information, about the whole Right to Information Act 2005. My dear friends, without widespread awareness, without educating people about the possibilities of this Act, this is nothing but a mere content of the paper. The right to information, like other rights, has some exemptions, like national security, from foreign policy, from defense, but also the judiciary. Judiciary is also exempted from Right to Information Act. Judiciary has no valid reason to claim such indemnity from this public gaze. Since regarding the appointment of judges, there is no accountability. How the RTI Act has not given the accountability in the appointment of judges. So I seek permission to publish my.
As my learned friend stated expressly that there is an overburden of officers of this RTI. By this RTI in the various institutions and the authorities. I was telling my learned friend that every PSU has to maintain a nodal officer from its whole organization. One nodal officer has to be maintained who will look after all this RTI. And he has to answer within 30 days. As well as when we go further towards that, the person as stated by the learned friend, that person has to go to office to get this RTI information. No, it's completely wrong thing. There is CIC, Central Investigating Commission, Central Information Commission, which is there by which in which you can just put on the RTI and they just send you the details, even for the PSU, even for the private sector. Third party information can also be shared by this thing to the extent on demand. As well as after the 2005 amendment, as my learned friend says that on demand the information is being provided. This is completely wrong. After the amendment of 2005, all the PSUs as well as the private sector have to publish their details, basic details, which are coming through the way of RTI on their website itself, so that RTIs are reduced proportionately as in the earlier time. As well as she stated the facts of judiciary and this. As we all are working in the courts and the judiciary, we all know how how careful the people are, how careful this work is done, and how transparent this work is. So I was not about problem.
Since my learned friend has raised the question about the overburdenness on the authorities who are there to answer the request from the information, and also talked about the Information Commissioner. Since I would like to tell you the Information Commissioner, Madha Bhushi Sridhar at Central Information Commission himself has said that in my office, Secretary doubles up the office staff to respond to the letters my office receives. How can they be expected to discharge responsibilities efficiently? Because there is no enough staff, there is no proper appointment of the authorities to deal with the request of the information which is made, since India is a largely populated country, no doubt. So there is clearly a overburdenness on the authorities. Further, moving on to the appointment of the judges. Appointments, there is clearly, we all know, there is no accountability regarding the appointment of judges. So the people demands how the appointment of the judges has been made, and there shall be a transparency on that fact also. So clearly RTI does not provide transparency on certain facts, and there is a clearly loophole in this matter.
My Lordship allows, I would like not to comment on the judiciary's work, how it was, how the judges are being selected, but I would like to answer the question about the statement, how she mentioned the statement of Secretary of the CIC, that the Secretary doubles up their work and just doubles up their staff to answer the questions, and their efficiency is decreased. Is that work? I think every year these CIC in different districts are being increased, and these staffs are being doubled up. There are being minimal cases of when wrong information has been provided and reported.
So my learned friend had talked about their CIC. The multiple CIC has been appointed in different places, but there is no clear provision. As we talk about other acts, there is clear provisions regarding the appointment of the authorities to provide proper redressal to the parties who want a request, who request for the information, the right to information, the right to know. There is no proper provision for that, and clearly the act is lacking that.
Article 19 only says that it's okay.
Okay.